Welcome, everyone. It looks like we have a few people still trickling in, but I'll go ahead and get started. My name is Sydney, and I am with the Nebraska Chamber of Commerce. Today, we are pleased to have you join us for our webinar, HR Hour, Ask Our Employment Law Attorney Anything. In discussions with our members and local chambers across the state, we've learned that the field of HR is evolving quickly. First, it was challenged by largely unprecedented times during the pandemic. And now the field is under pressure to recruit and retain talent in an increasingly tight labor market. So we have assembled a top-notch team of professionals to help us answer your questions. Our goal is to supply you with information sessions on a quarterly basis featuring different HR experts from the Nebraska Chamber membership to provide you insight into the world of HR. Before we begin, we would like to especially thank our lineup of co-hosts and sponsors, including the Nebraska Chamber, HR Simple, Knudsen Law Firm, and HR Nebraska. For those of you participating for professional credits, be sure to hang on at the end of the session for the reference numbers for the webinar. And also be sure to watch the chat for a coupon code to order the 2023 HR manual, which is created by Nebraska Chamber members, Knudsen Law, and HR Simple. I would now like to introduce you to Stacy Grant from HR Nebraska, who is going to be our moderator for today. Stacy.
Hello, everybody. Good afternoon now. It's great to be a part of this opportunity for HR learning today. I am the Workforce Readiness Director for both Lincoln HR and HR Nebraska, and all things HR is kind of my thing. So I would like to introduce Chuck Wilbrand, who's making himself available to answer as many of your burning questions in employment law as possible. He's prepared to discuss anything from needed updates to employee handbooks to the latest happenings in employment law and how they can affect your organization. Chuck joined the Knudsen Law Firm in 2012. He is licensed to practice law in Nebraska and Iowa and specializes in employment law, healthcare law, workers' compensation, just to name a few. Chuck has years of experience working in employment law, offering strategic advice to help employers meet their objectives while reducing potential litigation risks. Throughout this session, we will be answering questions submitted by all of you through registration. If additional questions come up, you can submit them in writing throughout the program. So thank you for joining us. We're going to go ahead and get started so we can hit as many questions as possible today. Okay, Chuck, here we go. So the first question is about state and federal rules regarding health insurance for companies of 3 FTEs or less. And can those companies provide a stipend or a cash in lieu for a health insurance benefit?
Sure. Well, thanks, Stacy. And just kind of at the start of things, want to always just give that disclosure and disclaimer that anything I'm saying today is not forming an attorney-client privilege, and there's no expectation that this is an attorney-client privilege. And I'm not really giving legal advice. I am answering questions, but it's not forming that relationship. So regarding health insurance and full-time employees, yeah, I mean, you can offer it in different ways. You kind of get into that situation of, well, what can I do in a legal sense? And also, what can I do to make myself as an attractive as an employer? What are my benefits that I can do? So there are some options that you can do that to offer, if it's full-blown health insurance, which, sometimes when you offer that, it's not going to be the best option. I know a lot of people go through their payroll provider to help put them more in a pool to go and have that as an availability of like, hey, we're offering health insurance, we're in a bigger pool, which can keep the prices down. Right. But that can be still more difficult area. But yeah, if you're using that as a benefit, that is options that you can look at.
Okay. The next question is, we have an employee that has been out on medical leave due to his non-work related accident. He's been out for 3 months and we would like to discharge him so he's not active on our system. What are the possibilities of him getting unemployment if we do so?
Well, there's a lot of concerns with just discharging someone when they're out on medical leave. I don't know what that means, if that's being truly out on leave under FMLA, or if they don't qualify for FMLA, but they have some other medical leave policy for that employer. There's some questions there that I think are concerning. But if you're discharging him, let's say you can discharge him with all those other legal minefields that you're going through, the possibility of him getting unemployment is really going to be coming down to the reasoning for the discharge. If it was performance-based and saying this individual employee was bad at their job and we discharged them for that, well, if you get, when they apply for unemployment, you have that a chance to participate in the hearing to try to deny the unemployment.
Okay. Thank you. Are employers permitted to deduct the cost of uniforms from an employee's paycheck with a written authorization?
Depends. If that deduction is going to make them go under minimum wage for that, I would be careful on that and looking at that. But having a uniform policy is typical. Yes, having them to buy it is typical. I get that. You don't want to be providing free uniforms for everybody, and how do you always do that when you get new ones and to make them work? But yes, it all needs to be in writing, and they would need to sign off on it. I don't think it'd be good enough just to put it in your employee handbook at the beginning. Sure, if it's hey, you damaged property and you have to pay for it, then yes, I would. That policy would be good in the employee handbook, but I would go and say communication. And when you're going to deduct that, they know it in writing before that happens and that they've agreed to it.
Okay, so make sure it's in writing and don't deduct if it'll put them under minimum wage.
Yep.
Okay, thanks. The next one is in regards to attendance policy and not following all the steps in the policy. So having a statement in the employee handbook that states the company reserves the right to skip steps in their own attendance policy. Is that, what type of risk does that put the company at if they do that?
Oh, you absolutely want that. You absolutely want that provision in your employee handbook to go and say, we are allowed to escalate this to whatever point for termination. So it really comes down to the discipline policy. Some employers will go and put a progressive discipline of step 1's a verbal warning, step 2's a written warning, step 3 can be a performance improvement plan, X, Y, and Z. But you want, as an employer, to be able to skip all those steps and terminate immediately in your sole discretion. Because some things are absolutely fireable offenses once they happen the first time. No warnings, you fire them. Attendance policy, yeah, I get it. But that's typically an issue where you want that progressive discipline on attendance policies. Usually, if someone misses work or is late to work once, probably not something you want to do as a fireable offense. Take that as a coaching opportunity. Talk to the employee, but the thing is, what you need to do is make sure yes, you need to have some leniency for everybody, but if you're not lenient on the person that isn't married and is dropping kids off in the morning, but the person that, and then the other person does it, you got to work with the person a little bit. But yeah, attendance, I think that's probably going to be progressive. I don't think you're going to fire after the first missed time of work.
Okay. Okay, this one is interesting as well. These are all great questions. This one is about creating a disciplinary notice for issues that happened prior to an employee going out on FMLA or short term. leave that were discovered while the individual is out on leave. A copy of the notice was mailed and emailed to the employee. Does this put the company at any kind of risk?
I guess it depends on what the notice is going to be. I mean, if they're truly out on FMLA, usually when they're out on FMLA, the employer doesn't have much contact with them unless it's, hey, are you returning to work? What are you doing here? Obviously, you can't ask them to return to work. You can't be interfering with their FMLA leave. But if you're putting them on notice of, hey, when you come back to work, we need to talk. I don't think that would be discrimination, or excuse me, retaliation or interference of FMLA leave. But I think it's wise to kind of give them that notice, and then when they come in, schedule a meeting as soon as possible to go over what you're going to do. And obviously, the more egregious it is, the heightened steps you want to take.
Sure. Okay, thank you. Do commissioned employees get the same time off laws as salaried employees? For example, salaried employees get PTO. Do commissioned employees get the same PTO and family leave, or is it based on whatever the company chooses to set up? And how do you calculate that pay?
Okay, so let's start with this. Nebraska does not have any laws on what is PTO and what is not. So there's no set that you have to give PTO. But if you give PTO, you got to be doing it, you know, whatever your company's policy is. Commissioned employees are employees. So if you're saying full-time employees have 2 weeks of PTO, and this is how you earn it, or how whatever your structure is for your employees, that employee should be earning that as well. Just because they're commissioned versus an hourly rate, I don't see how that affects. Then we get into salaried employees again. Depending on what your company does, I know a lot of companies are moving towards a no PTO at all, or excuse me, no bank of PTO. And it is, hey, if you want to take a vacation, take a vacation. If you need time off, take time off. As long as you're meeting your goals and meeting your expectations, we don't care. We're not going to follow it. You know, we're not going to super track it. Now, an advantage of that is whenever you separate from that employee or the employee separates from your company, you don't have to pay out any PTO bank. It is, look, we just kind of let anybody have it if they wanted it. And then when they leave, so then there's not that worry of, oh, there's this employee that's been with the company for, 10 years, never took a vacation, and now has 500 hours in the PTO in the time off bank. And when they leave, I got to go pay him all that money at his current rate. And that's going to create a financial burden.
Right.
And then regarding the family medical leave, yeah, if they're an employee, they're an employee. And if you are, again, if you meet the threshold for number of employees for the Family Medical Leave Act, they get it. They have to follow it. And then whatever your policies are regarding family medical leave is, which typically is, hey, if you go out on FMLA, we're going to run your vacation concurrently with that, so you will get paid on leave, because usually FMLA you don't get paid, but employers can go and say, no, we're going to run your vacation in accordance with that FMLA, and so then we get to where we're at. And then the last question was, I think you said, how do you calculate pay?
Mm-hmm.
Calculate pay, at whatever it is. I get it's a little difficult for a commissioned employee, but I would go and put that in writing of, hey, for getting paid time off, your commission is going to be at this set rate. Because if they're 100% commissioned, they're eating what they kill, essentially. And so you got to come up and, again, have that in writing and on an agreement of saying, if you are truly taking time off, PTO wise, do this. I mean, you can have a policy that goes and says commission employees don't get any PTO. Just needs to be clear and upfront, so there's no question about it, because then the commission employees like, well, I'm not going to work as hard, I'm not going to get paid. Well, yeah, if you don't work, you're not making sales and you're not going to get paid, so your pay is going to be reduced. So that's really kind of up to the employer of how they want to do that, but you can have them as a separate category as long as it's in writing beforehand.
Yeah, there seems to be a theme of making sure that everything is in writing.
Yep, communication's key.
Yeah.
And having things in writing is key, because if you ever get sued, the first thing when you go to an attorney, the attorney's going to say, okay, how was this done? I did it verbally. Okay, what does your policy say? We don't really have a written employee handbook. Okay, how are you making these decisions? And sometimes it's, well, our office manager's been with the company for 25 years. She calculates it. I don't know what she's doing. Okay, well, what happens if that office manager gets hit by a bus and they leave? Who's handling this? Oh, I don't know. That's why I'm always a big fan of keep things simple so that somebody else, if needed, can step in and, yes, after that learning curve, figure it out.
Right. Okay, let's see here. Next question is, how are employers changing their leave policies now that the COVID-19 emergency has ended?
Some aren't. I mean, some didn't even change their leave policies for COVID. So it's hit or miss on what they're doing with that. The big thing wasn't so much leave policies with COVID. Yes, there was the federal rule that came in and said, if they go in, you have to do, if they test positive, and this was early on, they get the 2 weeks and everything like that. But now, I mean, and then vaccination was a whole thing for about a year. Still kind of is, but that's kind of dropped off where it's not as much of a thing. So I wouldn't say leave policies changed so much, but those other policies that came up, it's probably good to still have something in place, but I don't know how many more pandemics we have to be a part of.
Hopefully none. Okay. How liable is a company if they don't include marijuana in the pre-employment or random drug screens, but test for it post-accident and the employee is positive post-accident?
The pre-employment and, the drug and alcohol testing pre-employment, it always depends on when you can actually do that. It really needs to be after the offer of the job, so you then can go and test them properly. I don't see that they're tied with one another. And when you're talking about liability and an accident, I guess it depends on what type of accident, because it's going to be coming a lot of things. If this employee is injured and they were drunk or high on the job, yeah, that you may be able to avoid workers' comp benefits depending on the circumstances. But if the employee was negligent, drunk or not, and they're acting in the course and scope of their business, and they go and call drunk or high on that, I should say, and they cause an accident while high, I mean, their negligence, no matter what, if they're acting in the course and scope of their employment, is going to be attached to the employer if they caused a car accident. That's through respondeat superior. So it's not going to look great if they're drunk and high, because then you're going to get questions about, well, how often does this person show up high? Have you had other concerns with them? What else were you doing? And it kind of goes into that. Might get into oh yeah, you were just indifferent, and you're like, yeah, I don't want that coming out, and you might affect the lawsuit or whatever it is.
So whether or not you test them pre-employment, really has no bearing on if that were to happen during employment.
Right, and I guess, the random drug test helps too, but, it shows that you have because if you go and say, well, we have a policy of drug-free workplace and everything like that, and you go and have a behavior showing, yeah, we don't really enforce this, we don't care. So-and-so showed up drunk on Tuesday, we sent him home.
Yeah.
Because it just goes through the whole culture of your company and what you're doing. If you're really following your policies.
Yeah, for sure. Thank you. Okay. Next question. How do you handle associates that have exhausted FMLA? What if they don't fall under ADA? What can an employer do?
Well, I don't know. ADA is very broad. And there is. So if you're going out on FMLA, chances are they're going to be also falling under ADA or something. Now, I understand FMLA, you can go and say, oh, well, my spouse is having this surgery, I need time off, I need to take care of them, or my child, or whatever. ADA, you can attach that to disability by association of, hey, I don't necessarily have the disability, but my spouse does, and that's the whole thing. So you got to be careful with that, especially when they're going out and, not working. But ADA has a different, different standard of is there a reasonable accommodation this person needs to return back to work? And it has to be a reasonable accommodation. The employer doesn't need to bend over backwards to get this person back to work. If it creates a substantial burden, then yeah, that could be it. But if it's like, hey, look, I need 2 more weeks of physical therapy, then I'll be back in the office. That might be a reasonable accommodation, just depending on what the burden is going to be.
Sure. Okay. I have a library director who is salary, who answers to a library board that the members are all volunteered, but they are responsible for hiring and firing. The director repeatedly comes in late, takes long lunch breaks, and misses work to the point of exhausting their sick leave and vacation leave. If this employee has exhausted their vacation leave and sick leave and decides they're going to take a vacation day, can we dock their pay for it?
Well, so sick leave and vacation days are handled differently. Or if that's what your policies say, they're handled differently. Because we got into a point of what's a PTO versus vacation, and now we've kind of moved to, if you do PTO, it's just like, we don't care if it's sick or vacation, here's your number of PTO. But if you do sick and vacation, then those are two separate, where sick leave doesn't need to be paid out on termination of the employee, where vacation does. I definitely have a conversation with this employee. I document and say, look, director, you do not have any more vacation days. You cannot take this day off. And if they take it off and they don't show up to work, you don't pay them for it, because there's nothing to pay them for. Now, I get it, they're salaried, and that comes with it, a whole other connotation of, hey, how are we handling this for salary employees? Because if they're salary truly exempt employee, and when people use the word salary, I'm assuming they're trying to say, look, they're an exempt employee, they don't have to work, they can work as much overtime as they want. Not really overtime, because they're an exempt employee, so they don't have to meet those requirements. So I think there's a little bit more of analysis that needs to go into that. Is the director truly a non-exempt employee? And if they miss it, yeah, you miss it. You may not be able to dock their pay, depending on kind of the situation. But I would definitely have that conversation with them. Sounds like that's at least a written warning if they're doing this continuously. And you may want to be looking for a new director, but I think you need to have a conversation with that director.
Okay, thank you. Okay, if we have employees that are currently exempt, but due to further clarification in laws should be considered non-exempt, what is the best way to go about that change? And is this a common thing to see now, or is it just me?
No, those things are changing, especially because the salary keeps getting bumped up, or they're wanting to bump up the salary requirement to be considered an exempt employee. I mean, there hasn't been a ton of changes in like the requirements of, look, this is what you have to do to be an exempt employee. Those ones haven't changed. The salary has changed a lot. Well, I think what you need to do is, once you find out that they are not really an exempt employee anymore, you need to have a conversation with them and switch that over to them and explain the process of, hey, you know, based off of new laws and everything, this is what's happening. You are now no longer exempt as an employee, which means X, Y, and Z. This will start on this date, and work with them through that process. The other thing you can do is, if it's a salary thing and you really want to keep this employee exempt, that employee's salary is going up.
Okay. If you work in the finance industry, can you do periodic credit checks on employees? For example, an office manager works for a financial advisor for many years. The employee passed the initial credit check upon hire, but over the years has defaulted on several loans and has mounting debt. Can the advisor implement a policy that they will rerun credit checks every so many number of years?
Yeah, I think you go and get their permission every time you're going to do it, and have them fill out the form. I get there in the financial industry, and I understand that mounting debt, part of me wants to say, well, does that matter? You know, what is this employee's role? If they're an office manager, are they in charge of all the companies? And this isn't just related to the financial industry, it's any employee, but you got to trust who you put in certain positions. Now, is there concerns that this person is misappropriating funds or stealing funds? Just because you have debt doesn't mean that you're going to go and start committing crimes. And so I think that's going to be a slippery slope of, hey, well, you took out too many car loans, and, you know, if they have debt, they have debt. It's the same way that you don't get to go and terminate an employee or discipline an employee because you have to fill out a wage garnishment interrogatory. Those happen all the time. Employees get judgments against them. Creditors go and garnish wages. Well, just because they're having their wages garnished doesn't mean they're bad at their job. But I understand hey, we don't want we got to make sure we trust this person, and I get that. I would just be, I would work with an attorney on whether or not we're adding continuous credit checks every so number of years, unless it's required by their license or something like that. I would be hesitant on it.
Okay, all right, thank you. Are we required to post salary ranges? So actually it's about, in Nebraska, are we required to post salary ranges? And if not, is that coming? And can we ask if an applicant is a felon? So first part of that was posting salary ranges, was just kind of a hot topic right now. But
I mean, posting
so is that in Nebraska?
On job applications or job postings
On
to
job
say,
postings.
hey, we have an availability. I don't think you have to. I'm not aware of any law that says if you don't put what your salary position is or your hourly rate or whatever. A lot of people are doing it now. Because people want to know, okay, I'm applying for this. What is it going to be? Well, sometimes you can, and that's always difficult, because I always go and say, well, I get it. You want to go and say it's just going to be, you're going to be compensated by experience. Well, what does that mean? Because is somebody going to waste their, quote unquote time to go and say, well, I have all these degrees, I have 3 masters and everything. I'm really qualified for this. You're only going to pay me $50,000 a year. Why am I wasting my time applying for that job if you think you're worth more? I don't know. There's the way I look at it is, and I know this is sometimes maybe not the most popular opinion, but the way I work at it is, it's not always about money. Sometimes we always think it's about money, and yes, that's how our courts are set up. Of any sort of release is all about money, but sometimes culture matters a lot. Are people going to be flexible? Matters a lot. Are you going to hate your job and your life, even though they're paying you a dump truck load of money? I don't know. Those are some of the intangibles that all employers have to look through. So no, I don't believe that there's any requirement to do to post salary ranges. I don't know if it is coming. Our legislature in Nebraska was kind of a mess this year. Not much got done, and when they started getting done, they were putting, bills together and everything like that. Next session, they can go and introduce new laws, and I don't know what's going to happen next year in Nebraska on that either. Asking about if an applicant is a felon, yes, you are allowed to do criminal background checks. But you got to be just careful on how you ask that question and go about that with doing criminal background checks.
So is that question, can you ask that question on an application, or is that something that you have to wait until an offer's been made to run a background check and find that out? Is there a certain
you might ask to get
process?
the permission to do it. A lot of things that come in is, people go and say, this is always going to be pending a criminal background check. So then they know one is coming. And then if the felon looks at it and goes and says, I don't want to apply now because I don't think I'm going to need it. And again, I think with some felons, it's, we have a justice system that in theory works and rehabilitates the individuals that get put into jail. And there's an argument that sometimes it doesn't matter if you're a felon because you're doing X, Y, and Z. I know some people go and have that connotation of, well, they're a felon. Well, what they were convicted of has nothing to do with what they're doing in their job. And those really aren't related. Why does it matter? And some people, but that's a different, everybody's different on that. I know some people that are more lenient on that. Some people go and say, well, you're convicted once, I'm never trusting you. And I don't care about what the justice system is. Okay, well, that's something you just gotta be able to work through and think about. And again, talk to an attorney when setting up your employee handbook and your policies. Don't just pull something off the internet or use ChatGPT to go and write an employee handbook for you. Because different states have different laws, and something, if you go and pull it off Google and you're like, oh, this looks great, it says Indiana, but I'm just going to change everything to Nebraska and I'll be fine. Well, we have different laws. There's different requirements. Federal law applies across the board, but that's where I think if people are doing it themselves, they need to be a little bit more cognizant and maybe talk to a professional about it.
Okay, thank you. Okay, so the next one is we have an employee out on workers' comp since 2017. And to date, we have been back and forth with workers' comp insurance and her doctor and offered her a light duty position for her condition to no avail. No response from the doctor. And my question is, how long do we have to continue to pay for her insurance with her technically not working at all? We can offer her COBRA, where she must pay it all out of pocket, but she currently pays $5 a week. And the employer picks up the other roughly $860 per month. That's just for the medical. They also pay the dental and a portion of her vision. She's also continuing to be counting in our city paid retirement and earning vesting years of service. We want to do the right thing and believe we all have all this time, but we are 6 years into this and ready for closure. How can we legally terminate her employment and not have a lawsuit against us? So this one is pretty in-depth and yeah.
Well, so workers' compensation is its own beast, and there are things where sometimes the employment aspect and the workers' compensation aspect sometimes don't always match up. Because from a workers' compensation perspective, is you want that person back to work as soon as possible, because depending on the type of injury and everything that goes in, once they start missing work, they're owed what's called temporary total disability. And so that's paid. I mean, if you have insurance, which you should always have workers' compensation insurance, do not mess around and get it. One, it's required by law. Two, if you have to pay that out of pocket by yourself, your whole business is most likely going to go under. One significant injury, the medical on that alone will crush you. So comp insurance, get it. But when the employee goes out on comp, your insurance company is paying the comp rate for wages. And that way that works is you calculate their average weekly wage, and then 2/3 of that is called the comp rate. And depending on where that is with the state maximum and minimums, that's what they are getting paid each week while they're out on what's called TTD. Now, once you get to TTD, eventually the employee should reach what's called maximum medical improvement, also known as MMI. Once they reach MMI, benefits stop. The TTD stops, and any indemnity payments stop, because that person has reached maximum medical improvement and can return to work. Now, the doctor needs to give, a work release. There sometimes will be done what's called a functional capacity evaluation. And what the functional capacity evaluation is, it will say how much this employee can and cannot do. And then that's adopted by the doctor. And the doctor can give those work restrictions. Then they can come back to work. Then it's up to the employer to go and decide, can we accommodate these restrictions? Now, sometimes even before reaching MMI, the doctor will give work restrictions to say, yes, they can work 4 hours a day, light duty. Great. That means you go and try to find a job for that person because you want to be paying them more. It's helpful for you. And then there is a thing called temporary partial disability, which means they're working some, but not working full time. And so that TPD payment is filling in that gap between what the TTD amount was and what they have earned. And if they are earning more than the TTD amount, great, no benefits are owed. So that's where you're kind of running into all of this. With it being out on work comp for 6 years, I don't know the case. I don't know the facts. That seems like a very long time of how we don't have an MMI opinion yet. Now, I've seen long work comp cases. They do go long. It's not a fast process. But that's something I'd look at. I mean, but that's all. I mean, yes, you could run afoul of some of the ADA stuff, but it's a reasonable accommodation. And then you get where you get. But I would definitely be talking to talk to your insurance company to find out what's going on, or maybe talk to the work comp attorney that is representing you. And then you got to talk to your own employment attorney with how you actually handle that. But I think that's generally how that works. But but work comp is its own beast, and you got to kind of balance sometimes those. Yeah, they should be working, but I don't want them to be working anymore. And how does that work with one affecting the other?
Yeah, it seems like a really complicated issue they've got going on here, especially if they've offered her a position within the restrictions that the doctor put her on.
Yeah, that's difficult. I mean, but then if they can work and she's at MMI and they're not accepting it, I mean, like I said, your work comp benefits are probably stopping anyways.
Okay, moving on to the next one. What are our options and or obligations regarding pay once a person exhausts their 3 COVID leaves?
I guess I don't know what 3 COVID leaves are. I know what it is under the contents of the sentence. But again, that's going to go to your employee handbook of how you do that, you know. And again, it's going back to what we've discussed previously with what if they exhaust all their vacation or all their sick leave. Sometimes you got to just handle that case by case. Because if someone goes and if they've exhausted all their sick leave, well, why are they sick? Well, they're pregnant. Okay, well, that changes the story. We probably are going to allow you to miss work that day because you're still because you're having symptoms from the pregnancy. You got to just play that by ear. And just got to, sometimes there's a little bit more of a nuance in there, but sometimes it's like, oh, well, this is the same employee we see who every Friday, says, I got a migraine, and now they're not here. So it just kind of depends on the behaviors of this employee, and what your previous conversations have been with them.
Sure, that makes sense. Okay, this is an interesting one. What are the laws surrounding audio recording in the workplace? For example, a manager has an office located next to a lunchroom. There is a video camera in the lunchroom that also records audio. It's discovered that from the lunchroom camera, conversations taking place in the manager's office can be heard and recorded. This includes phone conversations that are taking place as well. Obviously, only on the manager's side of the conversation can be heard, but the camera is still recording the audio and capturing what the manager is saying.
So in Nebraska is a one-party consent state, which means if the party decides to hit the record button and is having a conversation with one person or another, then yeah, that's been recorded. That party consented to it. If this audio camera or this video camera is picking up audio of other people's conversations in the lunchroom, neither of those two parties are consenting to that conversation being recorded. So what I typically, I mean, it's not always, but I don't love it when we have audio recordings in public place, video that's picking up audio in public places. I don't love it. So
in their example, say that they, in one of these recording, the manager said something that was pretty bad and they want to take some next steps with that manager. Is that going to be?
That could be an issue. Yeah. I mean, but there's some things to work through there. And I just would again recommend and advise, I don't know, I don't like video cameras picking up audio. Because that's typically not the purpose of the video camera.
Right. It's
in
this
video
instance,
camera,
it's for the lunchroom.
The video camera is to sit there and to monitor activity happening in the lunchroom.
Mm-hmm.
So if there's a fight or a disagreement or something else happened, great, you have the video of it and say, this is what happened. You don't need the audio of it. I mean, but we get into, I don't know, there's a lot of people just recording stuff now.
There sure is. Okay, what has been presented within the courts surrounding work from home as a reasonable accommodation? Have there been any particular court cases or rulings yet on that work from home aspect?
I'm not aware of any court cases with this from working from home. I mean, if you have the capability, I think that's a reasonable accommodation. If it is, I guess it would just depend on what it is of why that person needs to work from home. And I know work from home there's a split, obviously. There's some people that love it and never want to go back into the office. There are some people that say, look, I can't work from home because I got a wife, a kid, 3 dogs. I can't concentrate there. There are others that just say, yeah, I could work from home, but I'm just not as motivated because it's my home and I need to be able to cut myself off somewhere to have that break between work and home. So I think you got to look at it. If you have the capability and you're allowing other people to work from home, but you're not letting this other person work from home, you better have a good reason of why you're not letting that person work from home.
Okay. We are going to move on to, I think we got time left for a couple of the ones that were submitted to us on the Q&A. So it looks like our first one is an employee has an alcohol dependency problem. They went through rehab once and they were on short-term disability. He has had a relapse. How many chances do we have to give him? He is not a good communicator and does not tell his supervisor until he has checked back into rehab.
That's tough
Mm-hmm.
because alcohol dependency is going to be covered by the ADA. So, and I think really most substance abuse would be, but alcohol definitely will be. I think it depends on a lot of things. I think it depends on, yeah, I get it. He's not a great communicator. Well, he has other things going on as well. But he's also letting you know where he's at. Now, I don't know how long the rehab's going to be. I don't know how long these are occurring with one another. If they've exhausted, if he is even FMLA eligible, or if they've exhausted all of his time off and everything. So if that happens again, you got to look at the situation and say, look, we're going to terminate you. Once you get out of rehab, if if we have an opening, you're more than welcome to apply, and then you just do it you can look at it from that situation. But yeah, alcohol dependency is going to be covered under the ADA if you are going to be eligible for that. So.
Okay. And it looks like Sydney would like to hop in on the answer for this question too. Sydney, are you there?
I'm sorry, I didn't mean to do that.
Oh, you didn't. Oh, okay. We'll move on to the next question then. Okay. Is an online filing system within a company such as Paychex or Paylocity that an employer can upload documents, including any paperwork completed, such as pay changes, W-4s, etc. Paper benefits enrollments for record keeping in compliance instead of putting this in 3 separate personnel files. So we still keep work comp /I9 /medical documentation separate. Is a mixture of both frowned upon? So it sounds like they're asking if they can put those all into one spot where they can dump them in together rather than having to have them separate.
Yeah. I mean, I guess I really don't care how you do it. I guess the problem I have is if you use Paychex to keep all that stuff, what if you switch from Paychex? You don't have that independently somewhere else. What if Paychex goes down? How are you accessing it? I agree. Yep. Keep work comp and medical separate from the personnel file. That is not the personnel file. Personnel file has other things in it. But the work comp file and the medical file, yeah, 100%. That's separate from your personnel file. Yeah, I mean, you don't need to have an actual paper copy of everything. No, however you store their stuff, you store it. You just need to be able to access it.
So really, it's whether or not they have it, and then they're following retention policy. Of course, it's not really. It's not really how you have it. It's just that you have it and you can access it.
Correct. So if that's a benefit from Paychex, that's fine. I just know there's issues when, okay, everything's in paychecks, but I don't keep anything local. Okay, what happens if something happens with paychecks? You terminate paychecks or paychecks terminates you, and you don't have all those documents. I personally believe you probably should have it stored somewhere else as a backup,
Sure.
just so
Okay.
you can access it.
Okay. All right, looks like we have one more in here. When an employee is a remote worker, then goes on maternity leave, how does the employer make sure they are truly working after the leave is over? She has said she will be the one and only person watching over the baby. I've heard this question before. This gets complicated, but
You can call. I don't know what the person's job is for, but so if they're a remote worker and they go out on maternity leave, whatever that is, whether it's, hey, we'll just give you FMLA leave, you can take your own short-term disability policy out, we give 6 weeks paid leave, whatever that policy is for the leave, and they come back, you follow up with the worker. Say, okay, now that you're back from, want to make sure, connect, hope the baby's doing well. I have you slated as your return to work date as, August 2nd, making sure we're still on track for that. Let me know. Then August 2nd happens and you go from there. It's just like making sure anybody else is doing their work. I don't know what this person is doing, but if they're doing the work's getting done. And if the person is supposed to clock in and out each day, I'll let them clock in. Check their clocking in. If they're not, if they're a salaried employee that doesn't have to clock in or out, you should be able to still check and monitor their performance as a remote worker. Are they answering emails? Are they answering calls? Are they showing up for meetings? Or, are they getting stuff done? I think that's going to be a challenge with any remote worker, whether or not they're coming back from maternity leave or not, is, well, you're not in the office, so I can't walk by your office to make sure you're actually in your office doing something. As opposed to you're at home sitting on your couch and your laptop's open, but you're not doing anything. I think that's a challenge with any remote worker.
right. And then it says that she's the one and only person watching over the baby. It's going to be hard to do 8 hours of work or however much when you're the only person taking care of a baby. But if they're
Right?
getting their work done, so I guess it kind of depends. Are there certain work hours, or is this person exempt? Is the work still getting done?
Yeah, that's the challenge, is when they're saying, well, I'm going to be taking care of the kid. Okay, well, what does that mean? I know people that work from home and have their kids there, and it's just, yeah, hold on, I'll get to you in a second. I got to go turn on the show or get the person Cheerios or whatever. I mean, however they work at that, I think the employer, and this is kind of the dichotomy that's changed certainly in the last 3 years, is if you're paying them to do a certain amount of work and they're doing that work, aren't you getting what you bargained for? I mean, I don't know, that's always difficult. And you still look at it and say, is the work even really less if they were sitting in the office 8 hours a day and they were sitting there watching YouTube when you're not in? I don't know.
Right. Okay. Well, it looks like we have gone through all of the questions submitted and the ones submitted here online. So we're going to go ahead and wrap things up. We're just pushing